That's its own.
Okay, are we ready? I'd like to call to order the Village of Biscayne Park Code Compliance Board meeting for Wednesday, August 19th. It is now 6 p.m. If the clerk would please call the roll.
Janie Anderson, Dale Blenton,
Present.
Rodolfo Barrantos, Judy Hammerberg, Michael Lanat, Doreen C. Grant, Rafael Gutierrez, Vanessa Cherry present.
Good evening again, everyone. This is a meeting of the Village of Biscayne Park Code Compliance Board. The board is authorized pursuant to Chapter 14 of the Village's Land Development Code to ensure compliance with the village's code of ordinances. The members of the board are citizens and residents of the Village of Biscayne Park. We volunteer our time and we're not paid for our services. The purpose of each hearing is to give any alleged violators the opportunity to contest the completion of the code, which resulted in the issuance of a notice to determine whether a violation of the village's code has occurred or is occurring. It's too staticky. We are not authorized to dismiss violations based on hardships, ignorance, or the fact that others may be guilty of the same violation. These hearings are conducted in a quasi-judicial manner. Our responsibility is to act much like a judge in a court, and that is to hear cases presented by the village's code compliance officers and to hear contradictory arguments presented by the alleged violators. We are not authorized to change the code. The village commission is solely authorized to enact or revise codes. Conversely, neither the commission nor the village manager have the authority to overrule the findings of the board. Pursuant to Chapter 162 Florida statutes, orders of the board can only be appealed to the Circuit Court of Miami-Dade County. We have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding code compliance officer's decision, we must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. All documentary evidence presented by the parties must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code compliance officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in direct examination, to impeach any witness regardless of which party first called them to testify, and to rebut the evidence against them. If you intend to address the board and have not signed in, please do so. Anyone wishing to address the board, please stand and raise your right hand so you may be sworn in. You are reminded that this board is a quasi-judicial board and giving false testimony can be penalized.
Please stand up,
Stand.
raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Do we have any additions or deletions or changes?
Yes, we do. The addition is the second case we will call. We'll call one case first and then call it second because that's
One that
the abatement.
the nuisance abatement.
Correct.
Call your first case.
First case. I think this mic comes up. The first case on the agenda, I'm sorry, my name is Doreen Grant. I'm the co-director for the Village of Biscayne Park. Good evening. First case on the agenda is in section 8, fine reduction. It's 8.1 for the address 12025 Northeast 8th Avenue. Case number CE 25 0592 for Andrew and LaMiss Wilson. This is a fine reduction. They were violated for under section 8.431F, property maintenance. The exterior wall awnings were in need of cleaning. They have since come into compliance and we filed an affidavit of compliance. The outstanding fine is $10,750. They are offering $250. Our recommendation is $750.
Questions from anyone on the board?
I think this is about the last one. So, nothing to happen, but, yeah, and, bring it into the compliance.
If you both would introduce yourselves and your relationship to the property.
I'm LaMiss Wilson, owner.
Andrew Wilson, owner.
Floor is yours.
We don't want to just say we don't want to pay anything since we fixed it, but $750 sounds a little bit too much. It's going to take away from my budget of doing better for the house. And, you know, as you guys know from last time, I'm about to do my windows. So $750 sounds a little bit steep to me. I honestly think that the administration fee of $250 should be enough. But I don't want to offend anybody or go against the rules since I'm learning about this. So you tell me what we can do, but $750 is a lot. It's going to take out of my budget. I'm doing my windows.
I'm gonna be quite honest. This went on a long time.
Mhm.
And while there was indeed a great deal of communication from you folks, staff, it was a lot of adversarial situations and the case did drag on. 250 does not take into account the significant amount of staff time that went into all the processing, all the back and forth, the times you came in front of the board. Personally, I would not be comfortable accepting 250.
Mhm.
No, I would, I don't, we could have made it, because this has been a month since, October 2024, we first at this, and then this violation, almost, 7, 8, 9 months later, it's a violation. There was another enforcement. Second or in October, the second order, in 2026, where there was a fine of $250 and an administrative fee of $250. So that in and of itself, we're not apt to
Mhm.
because those are constantly
Mhm.
and
That's why I was offering 500
and
to
then
just
there-
cover those.
And then there was another order of enforcement where we'll help that they don't mind and pay us until for the period. And months ago, now we're here today, so I am in, yes, I would not.
So you don't, what is it that you guys think is
The
appropriate?
first thing you have to do is make a motion on your,
Okay.
in the case of CE 25-0592, the property is now in compliance. They're offering $250 for their fine reduction. I would make a motion to not accept $250.
I'll second.
Um,
Well, the village has,
All in favor?
Aye.
Aye. Any opposed? Motion passes 4-0.
Every time it comes before the board, our employees put together photos and a whole packet for us of all the communication, all the photos. It's a tremendous amount of time. And we feel it's unfair that they get reimbursed for what they, in
The city gets
city gets
reimbursed,
reimbursed
right?
for the work that our staff does. Each time we have a large packet of information that we have to go over and that the staff has put together. So 250 doesn't cover.
You heard what staff is suggesting. I would the ball again is back in your court to make the next offer.
But I mean, the miscommunication was not only, I don't know if this works. Miscommunication was not only our fault. I feel like the village has a little bit of responsibility. Miss Grant has a little bit of responsibility.
What we're talking about Kim, is the level of work that's gone into the various
The level of work didn't even need to get to that point.
heard staff suggestions. Heard our feelings. and-
750 is a lot of money, you guys. Come on. 750 and we're working on the house and we're trying to get it better. I mean, it's like you're shooting us in the foot a little bit. I understand the then maybe hire somebody that can communicate to us village residents, not somebody that wants to come into our house and not be nice to us.
You want to make your next offer.
I can't do 750. I can't, I just can't. It's not in the budget. It's, come on. So we said 500 and you guys know on that either? No 500 either? That's not good enough?
Then. I don't personally,
Second,
that just covers the one quarter of the budget. Like I said, you've now been here for, this is the fifth time, I believe, just this.
This is my second time here.
Your second time. The case has been before us.
But if the miscommunication didn't happen, we would have been fine. Okay.
For this board 5 times.
Okay.
And that concludes tonight. In addition, there was notice of violation and a notice that was part of that steps that were appropriate to be trying to do. So I think that village's offer of something extremely friendly. I would like to see them ask or suggest more, but I simply think.
That's
yes.
nice.
I'm just saying, I
That's
would,
nice. We appreciate that.
so. I'll make a motion to deny on case of CD-25. 725. 532. To deny the file.
I'll second, on favor.
Aye.
What do you suggest we do, ma'am? I trust you, ma'am. What do you suggest we do?
The offer has to come from you. You've heard the suggestion from staff. You've heard our reasoning behind not being, quite honestly, I was surprised that staff came in at 750 when you consider the amount of work that's gone into it, but I respect them. They know the amount of work it took. I respect it totally, and I certainly will not contradict them, at least not right now. So you know where we are.
I mean, it is what it is, I guess, 750.
You'd like to make an offer of 750.
Yes.
Make a motion to accept compliance in case CE 25-0512 to accept their offer of $750 on the final reduction.
I'll second.
All in favor?
Anyway,
Oh, I'm sorry. Bear with me. Fine to be paid by September 9th, or the fine reverts back to its original state.
You want us to pay by September 9th?
Yes, ma'am.
Okay. So we can just go there and give them a check or a credit card. Great. Okay, thank you, guys.
Thank you.
Next case on the agenda is Section 5, the addition.
Let the record show that Michael Lanat is here. I'm so sure. So, clear on the motion. 750 to be paid by 9 minutes. All in favor?
Aye.
You opposed?
The next case is under Section 5, additions, deletions, and changes to the agenda. This is an addition. 5.1, admissibility of police, or is that what we're doing? No, we're doing 5.2. I apologize for that. 5.2, we had 2 additions that I should have recognized that in the beginnings. So we're gonna do 5.2 because the gentleman is here. So it's for 1060 Northeast 120th Street. It's case number CEN 26-0294, Carla Lambertini and Augustine A. Conti. We are asking for an order of abatement in this case. A tree had fell, and before you is a police report dated May 25, 2026. This was an act of God, I have to say. A tree fell from their property, their private property, fell over onto public property and completely obstructed the street. So police had to be called to the scene, and they had to immediately call for abatement. We had to clear the street. So in situations like this where, you know, the tree came from private property, the city cannot take responsibility for that. They had to charge the property owner for the vendor.
Before we go any further, I need, in the case of total transparency and honesty, the property owner in this case used to occasionally reach out to Bob when Bob was on the commission. And a couple of times in the years since, he's reached out to him. Mr. Conti did in fact contact Bob regarding this. Bob knows better than to involve himself in any code issues, so the only advice he gave Mr. Conti was you might want to meet with the manager or meet with one of the current commissioners.
Right.
That's as far as it.
Thank you for the disclosure. The chair did let me know ahead of time that she would be making that disclosure, and respectfully thankful for that. Mr., would you like to go to the?
Good evening, everybody.
You would, sir, I need you to identify yourself and your relationship to the property.
Yes, my name is Agustin Conti. I'm the owner of the property in discussion. I want to give you packages of this, but I only have one. I'm going to show you a little bit so you have an idea what we're talking about. I'll be brief. I know your time is important. Good evening, Chair Anderson and board members. My name again is Agustin Conti, owner at 1060 Northeast 120 since 2009. I wish we didn't have to spend our collective time on this tonight, but after receiving a vehement and dismissive email response from the village manager, I'm here not just over a disputed bill, but for moral reasons, to stand up for what is right and hold public officials accountable for how residents are treated. I asked the board to dismiss case CEN 260294 because no code violation occurred and that the administrative process executed by staff was fundamentally flawed. I care deeply about our local canopy. In fact, that's one of the reasons why I fell in love with Biscayne Park. My property features a massive black olive tree with 5 columnar stems, which means branches that fall off. It's not one tree, it's a big tree that has 5 big branches stemming from them. A tree I cherish it carries so much that years ago I turned down my children's request for a tree house specifically to protect its health, not within reason. I had no reason to believe that a tree house will create a problem. It's just, you know, out of love for the tree. I have maintained it responsible for the 17 years that we've been here. As shown in my records, my last full professional trim was on March 19, 2023. 3 years and 2 months.
Would have to be handed in, so we can't see evidence off your iPad.
Should I show you this? Oh,
Need hard copy to go in the file.
okay.
What I read
I didn't know
in the
this.
beginning, yeah, it needs to have hard copy.
Okay. Should I proceed reading or? Okay. All right. As I said, the professional trim was on March 19, 2023, 3 years and less than 2 months before this event on May 25th of this year, well between the standard 3 to 4 year cycle that I was recommended. On May 25th, a branch fell due to solely the unusual structural angle of that specific stem. Responding police officer Frank Celiano, who was incredibly supportive, I must say, he stated repeatedly that this was an act of God, reassuring me, don't worry, the city will clean the street. Central to this hearing is my official complaint regarding staff conduct. That morning, the village called a private contractor to my lawn, and public director John, who I didn't know, walked past me. I learned this after the fact. Without introducing himself, this was a very stressful event for me and my family. We were very grateful that nobody got hurt. It was a big branch that damaged one of my cars significantly. when I approached the contractor, I wasn't directed what to do. The contractor told me that I would have to pay for the damage in my side. I said, okay. And that's when Director John from FAR interjected and showing me with his boot into the grass. He marked 5 feet from the pavement on the street from the curb and loudly declared everything past the mark was my financial burden. Under that direct official instruction, I negotiated on the spot and paid the contractor $600 out of pocket to clear my private lawn immediately, which he did. It was only later when I called the contractor to question the additional invoice that was handled to me, that was days after, where somebody from the city, yes, while I was, did you deliver the notice? Okay, I was taking pictures of my car when I received a bill addressed to the city for $800. And that wasn't addressed to me. I felt that I was wrong on its own. I called immediately the contractor and he said, I'm sorry, I billed you for what you're supposed to be billed. I billed the city for what the bill's supposed to be billed. So I dismissed the bill because it wasn't under my name. Under the direct official instructor, John, I negotiated on the spot and paid the contractor $600 out of pocket to clear the loan. When I submitted my formal complaint regarding Director John's misconduct, Village Manager Albert dismissed it outright, claiming in his response that he was there that morning.
We are not here to get into personality conflicts. We really are here dealing with what you were presented, which is in fact fee for service. The village had a legal responsibility to get that cleared off, get that street open. And yes, because that tree came from private property, the bill will be generated to the homeowner. And we can talk about a lot of things, but we're not going to get into personalities and who should have behaved differently and whatever. We weren't there.
I understand. All right, I'll finish in regards to the tree. I'll skip a part if you allow me. I was always worried about this tree, determined to ensure the total safety and worry about my upcoming family vacation. I acted immediately. I consulted 2 separate arborist professionals, choosing a recommendation that preserved the health of the tree rather than necessarily cutting it down. On June 5th, right before leaving on vacation, I paid $1,800 out of pocket for a comprehensive 1/3 crown reduction trimming, and the tree has been completely safe, balanced, and sound ever since. I acted in total good faith, maintaining my property, resolved the loan immediately for $600, and invested another $1,800 to ensure permanent safety. And my reason to request this to be dismissed is because, as Doreen said, and as the police officer said, there was no storm that night. And as the arborist says, which I have no problem at all in bringing you their assessments, I just didn't know that I had to present this just like a court case. The fact that I did not neglect the health of the tree or the care for the tree. I understand it is your decision that I have to pay that. I'm not here to discuss that, but I'm here for what I feel is right. And I care about that tree a lot. And I did everything I could, and this was simply an act of God. And for that reason, I'm asking you to dismiss the case. Thank you.
One of my trees falls. Oh, sorry. If one of my trees fall and it falls out into the street, and it's an act of God, an act of Wilma the hurricane or whatever, it's still my responsibility.
Well, if it's a storm, I understand the city intervenes. It's not just if there is a hurricane or a storm, the relationship between who pays and who doesn't is very different than this single situation, in my understanding.
Hurricane on me. I have to pay for the cleanup.
Well, I'm kind of interested in, can you guys hear me? I'm
Yes.
kind of interested in the discussion that you had with this guy, John, you said his name was?
The public,
John Jenkins.
yeah, he showed up at the scene and I didn't introduce himself or anything. I felt pretty bad, but as I said, that's supposedly.
Irrespective of that, he made a representation to you that you were responsible for, he measured off 5 feet.
Yes,
and said you're
he
responsible.
actually,
Hold on. I have to say
ahead.
my whole statement before you speak.
sure.
So he told you that he marked off 5 feet and said you're responsible for 5 feet going forward into your property, and that's your responsibility.
Yes,
As a consequence, you made a deal with the contractor to clean up the area that was 5 feet in that he marked off with the tree that fell, and paid the contractor for what was the debris that fell from the tree 5 feet in on your property.
correct.
Okay. And there was still obviously more tree that was in the road, right?
Right. He was already working on the street based on what they determined. And I only when I approached the contractor, I find out that, based on the direction of this guy, John, that I had to pay for that. And he told me they will pay for the rest. This is what you need to do. And based on that information, I negotiated with the contractor. Had I known that I had to pay for the whole thing, I would have probably make a different deal, or I would have been
Do
armed,
you have
equipped to.
Evidence of the payment?
Yes, I have the
600?
bills. Yes.
There's two separate things, because yes, the private property, he would be responsible. He could have told Joe, no, the tree guy, no, I'll take care of what's on my property, not even dealt with him. Joe could have, Joe's tree service would have taken care of what was in the city's property, right of way, would have taken care of that, billed the city would then bill the resident. So it's two separate things. His deal with Joe could have been yes, no, that's too much, that's not enough. It's still the.
Yeah, I understand that, but what I'm getting hung up on is there was a representation made to the homeowner. Did he make any representation to you about what was going on, who was responsible for what's out in the street?
You're talking about John?
Yeah.
Yes,
What'd
he
he say?
clearly said, in fact, he only intervened when he saw me talking to him again, without introducing himself or anything. And he marked with his boot, this is 5 feet from the pavement with his boot, counting 5 feet. And from here on is you. That's what he said. And that from here on is exactly where I have my hedges. So I said, okay. And that's when I proceed to discuss with the private contractor. Had I known that I had to pay for everything, I would have discussed a different deal, or I would have arranged it differently. I have to say that the contractor was already working on clearing the street, okay? After he started with his crew that, okay, what I'm gonna do with this? It was a very stressful situation for everybody. I didn't feel supported at all by the city, but again, supposedly this is not important, but I feel it's incredibly relevant to what I had to pay, and then realizing later on that I had to pay another $800 that the contractor didn't care to explain either. That's not his job.
So your hang up is that if I would have known, this is you saying if I would have known that I was responsible for the whole thing, I would have negotiated another deal with Joe, the contract.
Absolutely, absolutely. I was misled by this guy, John.
Okay.
Reminder, this was Memorial Day. It's a miracle that anybody even came out. I don't know how much negotiating you could have done with any other vendor to get a better price when it was Memorial Day.
Well, I don't think, just like, there wouldn't have been a negotiation for what was in the city, what was on the city's land. The city was taking care of it to get it.
Exactly.
So that we could have a passing on. So the city would have taken that, it just would have been what this gentleman had to do on his property. Once again, he could have said, no, I see where there may have been a misunderstanding of what was being said, or not a clarification, but I don't see where, if what he said was correct, that John misrepresented anything. He goes, from 5 feet back is your responsibility.
The $800 bill,
The rest of it, meaning the city is cleaning it up, but from on your property back, you have to take care of it, or it'll sit here.
is the $800 strictly for what had to be done on city property?
Can we have that mic louder? I can barely hear you.
Is the $800 bill, does that include them cleaning up on your side? or
No,
is it-
no, I have my bill to my side that was $600 that I can
Oh,
show you.
That's what I thought.
And days
This
after,
is back what Dale said.
yes,
It's two issues. $600, if I understood you correctly, was to clean up what was on your side. The 800 is what is owed to the city for the cleanup on the city side.
Yes.
Issues as Dale explained.
I have to say, I'm so sorry. I have to say, I'm very sympathetic to the property owner because what happened was obviously not intentional.
No.
It's an act of.
or neglect on my part.
However, in a normal situation, what would have happened, would have been, I would have been called to that scene. It was a holiday, so unfortunately I couldn't be.
Worse, right?
But Raphael or myself would have been called to the scene and we would have offered the owner of the property owner to do the job himself or hire someone to do the job.
So you would have given the homeowner the opportunity, even though it was in the public roadway, to do something about it?
The tree fell onto, the swell. We would have given him a day or 2 days to clean it up or pay someone to clean it up. In this situation, and I want him to understand, the reason why we had to move it from level 0 to high level was because the public street was blocked, and that became a state issue. We cannot go against what the state requires us to do. We cannot block a public right of way. An ambulance was coming on that day and couldn't go through that street. This whole village would shut down because the state would come for us.
Absolutely.
So the police had to do what they had to do to clear the street, which is we had to put a vendor right away. We had to have John out there. If John could clear that street, if he could cut the tree and clear the street, we wouldn't have had a vendor, but it was a much bigger job. So John did what he needed to do, and I wasn't there, so I can't speak for him and what he did or what he didn't.
Well, that's what I'm getting hung up on. What is it that we have to say about the alleged misrepresentation?
Not to comment on that. John is not here. If I knew this was gonna come up, I would have had him come and testify.
Right, but I felt directly impacted by his actions that day. Nobody told me what to do whatsoever. He only said that, and that's wrong because I had to pay. He didn't dare to explain.
His public street was blocked.
That's very clear, and
Police would have been out there, which the police, when you read the report, they were out there
the police did.
5 hours. And we are not even charging the property owner for that. In normal situation, we would have charged him $75 an hour, but the police decided not to.
So let me ask you something. Have you determined by virtue of what you've testified to as a misrepresentation about the difference between the amount that you're getting charged now and the amount that it would have been?
Yes.
What?
I haven't come up with a number. I used the same vendor to end up trimming the tree. I think he's a fantastic vendor. I would have probably dealt with it differently, certainly differently. I would say probably in the order of, I don't know, 1,000 to 1,200, something along those lines.
Well, this is less than 1,000 for is.
I'm talking about both. I'm talking about the whole scope.
But what I can do is from personal experience, and I did have an extremely large branch fall also, and it was a $7,000 branch, and it was reason it was so expensive is because once it's on the ground, it is more of a hazard to the workers cutting a tree that's a branch that's on the ground than in the air. I thought I was a little taken back, but no, it was a big branch. And I learned a lot.
Oh, yeah, you do.
And once again, the trees that we have are well maintained, and we have them every 2 to 3 years come out the office and maintain them, but it fell. And it was the next citrus.
And you paid the $7,000? And the 5 hours that you're talking about, Doreen, that was 5 hours of who, the police out there?
And if you read the report, it will tell you the time they arrived at 9 o'clock and they left at 2 p.m.
And there's no invoice that's being charged to the homeowner for that?
I went through the report with him because I wanted to make sure that, you know, we are not just representing the city, we are representing you as a resident as well.
I didn't feel represented at all. The police did a fantastic job, by the way, I must say. Clearly.
This
Sure.
is essentially fee for service, and if you remember, when we hear fine reductions, we do not touch fee for service. Makes it a little bit different. I appreciate the frustration. Nobody wants a bill of any size that they didn't expect. But again, I think Dale, thank you for explaining it so well. 2 different issues, both have to be dealt with. And thank God there was somebody available on Memorial Day.
I mean, I empathize with you, but the bottom line is that you know that you know, with regard to if a tree falls down in your neighbor's yard or in a public right of way, that, you know, that was your tree and there's a responsibility for that. It sounds like your beef is between $200 and $400, you know, in the grand scheme of things, between 1,000 and 1,200, aside from the personality, misrepresentations and all that. But if you get down to the numbers, that's a number that was incurred by the city. And you were not charged for the time that the police were out there directing traffic. So,
There's saying that the streets has traffic is almost laughable with all due respect. I understand how that functions with the police, but thinking that I have to pay for the police to direct traffic on my street is something that it's hard to swallow.
you did
To
it.
swallow.
Blockage. If you
justify-
have to close off the street for construction or anything else, the contractor has to pay for police to redirect.
Right, but
Because
my
also
taxes don't pay for the police to.
No, you did.
service.
You're not getting charged for that.
Okay,
That's what
thank
I'm
you.
saying.
So I have to be grateful for not being charged by the police.
No, you know.
I'm trying to understand how
you're-
things work.
But they have to stay on scene because it was a safety issue, pedestrians, animals, vehicles. So they have to stay there to make sure everything is removed from the public street before they can let public use it again.
If there's anything else, I'd like to make the motion. Case number CEN -26-0294. Like to, threaten the village to, initiate an order of abatement for $800. To be paid by September the, 23rd,
Fine.
be paid by September.
All in favor?
Aye.
Motion passes.
Thank you.
Would you like me to go ahead and put the addition 5.1 on the record? Or would you like us to go ahead with the rest of the agenda?
That's an addition? Another addition?
Addition 5.1.
I will say on the record, you're claiming they're not.
Correct. Yes, I would like to put it on the record that the village attorney will not be able to attend this meeting tonight. However, I would like to enter into the record admissibility of police officers sworn incident reports at Code Enforcement Board hearings, requirement for in-person testimony. So the village attorney gave a legal opinion and it was provided to every board member. Absolutely. Okay. Well,
Exactly, that's what I was thinking.
Okay.
Well, actually, why don't we table that session and then we can go from there.
Okay, table to the end.
I want to be discussed. We should number the one we just heard as 5-2.
Yeah.
Number. Okay.
Next item. Item was 6.5, 6.6, and 6.7. These are for the address 923 Northeast 108th Street. The first case number EEN 20-0413, Brandon Leno, JTRS, and Walansa Kiefel, JTRS. We are here for an order of authorization to foreclose. They were found to be in violation of Chapter 16, permits required, double fee permits. The garage enclosure was The garage was enclosed without permits. And this is an old case. It's gone through adjudication. Now we are at the end of the process where the village is asking to foreclose on this property. May I read all the cases? Do you want to do them but one by one? Read them?
Well, it looks like three of them. No, I'm sorry, two of them we would take back. Those are the two foreclosure cases.
Okay.
Yes, and the other two are.
And the other, correct, we are going to ask for intent on them.
Everyone will take 6-4 and 6-5 together.
Pardon?
You take 6-4 and 6-5 together. They're the two foreclosure cases.
Yeah.
May I read 6-4 into the record?
Yeah.
Same address, same property owner. Case number is EEN 19-1953. Found to be in violation of chapter 16, permits require double fee. A wooden fence was installed without permits. I mean, there was other construction work that was done and added into the same case. Unfortunately, it shouldn't have been that way, but we'll go with the wooden fence installed without a permit. We didn't issue this violation. It's from the past.
Right, right.
April of 2019.
Yeah, I just have questions. It's a homesteaded property or not?
Now homesteaded, yes.
It's not homestead.
It's homesteaded.
Yeah, it's homestead.
Yes, it's homesteaded.
I can even see it in there, so I'm not sure.
It's homesteaded and in a trust.
This is 6.4, you said? So this was adjudicated back in 2019?
2019 is when this particular violation was issued at 6.4, and 6.5 was issued in 2020.
So it's just been accumulating daily fines?
Yes. Been through adjudication, and we filed the lien, and it's been accumulated.
Yeah.
Accruing lien.
Just tell the lien was filed for 82,300 and the ongoing daily fine of $50 continued. That was back in, January the 17th, 2024. And there was also an administrative fee, fee, and then, up to date, it's $129,000, $550.
And what communications that you had with the homeowner since 2019 about this?
Been the board, had personal conversations with him about how we can go about, applying. He's very cooperative, I have to say. It's just that the family has gone through some issues and it was a little bit difficult for him to take this down.
But
While, and I mean, I had this conversation with him today as well.
I mean, isn't part of it not getting permits,
Um,
double fees?
Yeah.
And
Applied for a permit last year, but,
I'm gonna ask you
oh, yes.
your name and your relationship to the property for the record.
Brandon Lino, owner.
hold on a second. So with regard to the permits, what's happening with the permits? Because that's something that you would come down and you would have conversations with. You can get it, you can't, you pay the double fee, you come for an abatement or a dispensation on the fee, but none of that's happened, right?
It hasn't happened, yes, and Brandon would be able to explain why. They've had issues in the family and that's why he hasn't. However, we have communicated, I've given the options, of how he can come into resolution with this. And several times, not one time.
Okay, so you gave them options how long ago?
I would say over the years, maybe a couple times.
Yeah.
And have any of those options been moved on?
Yes, some of them, he has been able to comply with the swimming pool and some other stuff that were there, the smaller violations. But this particular violation for the garage is a big one. The garage was converted into a room.
Right.
So
But now, that's what I'm actually focused on, because with regard to that, you did it without a permit, right?
they applied for a permit, I believe, a while back, but that permit stalled. Yeah, it was abandoned.
You abandoned it. Okay.
More than slightly disconcerting is that there are 4 major situations, all of which are significantly old. Right, sir, I'm gonna ask you straight away. Deal just with the first one, the one that has the bank, et cetera, starting.
Can you talk in the mic? It's kind of hard to hear you. He's talking
It's
about.
it's hard to hear you,
Yeah,
Cheney.
That's
It's hard
right,
to hear
yeah.
you.
I hear you, but it's like kind of hard to hear you.
Uh,
What was the question?
The one that's gone on since 2019.
Okay, so,
Issues.
mhm.
You're right, sorry. Better? Oh. Better?
Much
Okay,
better.
thank you, sir. The one that started in 2019 that has multiple issues, starting with the wood fence. Realistically speaking, what is your plan?
Okay, I hired a contractor, a professional contractor, and the permit's been put in actually as of last night. So that's for the garage and for the double fence. This issue has been ongoing. It's basically straight up neglect. It's family issues, it's hardships, but end of the day, this should have been taken care of. And it's just negligence at the end of the day on my behalf. So I take full responsibility. But I do ask for grace and an extension saying that, hey, going forward, I will be in communication with her because now I'm back home now, working from home now. So these issues should be doctored up.
You said that you hired a contractor and he applied or you applied for a permit last night?
He not applied, but he actually uploaded all the documents and applied for it last night.
Doreen? They all there?
But you have to go to P.
They'll have to go to the Planning and Design Review Board, but the documents are there. that we looked
Okay.
at.
He's,
And that's for what's on this first case, fence, construction, electrical, mechanical, plumbing.
That's for the garage and the double fence fee, both fence and the garage.
All
Correct.
The application for that has been submitted.
It's yes, I'll say yes, and it's because the violation for the garage conversion has all the mechanical, the plumbing and electrical work.
Okay.
there.
and the permit has been paid for the double fee and all that stuff?
Before he pays, yeah.
But he did everything to get it there.
So at least in terms of the first case, EEN 1953, all applicable permit applications have been submitted. Okay.
And can I ask another question of the village? How far in advance, I mean, is there any, this just has to go to P and Z. P and Z meets every 2 weeks. They just had a meeting this past week. So within by the end of September, there should be
I believe so. There should
three
be three meetings.
meetings that he could attend. I mean, that if one, the first one, they needed.
It doesn't go to the.
Information, they need to have
yes,
2
so
more
much
meetings.
answer, Yes.
What is their last one in September? I don't have my sheet with me.
I do, but this one's off, thank you. It's kind of hard.
Kind of change the dates a little bit, but
I believe it's
I
the
think it should
28th.
be the
If we say,
second week.
it'd be safe to say by the end of September, they would have,
September, yes.
okay, there would be at least 3, 28.
Let's try this. See, September 28th? No, it isn't working, definitely. September 28th appears to be their last meeting.
Oh, legal state doesn't update it.
Yeah, it says the 21st, but it also says the 28th. Do we know which one? 28th, okay.
If there are no other questions, I'd like to make a motion on case number EN 19-1953, to table, to bring this back before us. Give the property owner until, when is our hearing in October?
21st.
Give the property owner until October the 16th to have fully issued. Oh, yeah, to have fully issued permits that relate to this case before us.
I'll second. All in favor?
Aye.
Any opposed? Motion passes 4-0.
So what you need.
Get her
to do
done.
is- Yeah, at least get, no, he's not. He has
No,
more.
no, you still got several more.
Oh, for this one, you just need to make sure you get your permits, a fully issued permit by then come, back and forth with regards to the foreclosure issue.
Okay, and that's for the
Wait.
fence or the gate? So you guys are talking in code.
This first one on case number, 1953.
Okay.
That was for the.
The fence, the garage, right. So the point is, the daily fines and the lien will still hold until all this is settled.
I understand.
But we'll hold off the foreclosure.
Right.
Okay.
We're just tabling it, get your permits, then it'll be, come back and forth.
Okay.
Give you some time.
I read 6.5. Would you like to rule on that one as well?
Is
That's the garage and.
same thing? Oh, yeah, that's the garage enclosure. So Gil, if you want to make the motion,
Yep, case number EEN -20-0413. Table the case until October, the property owners to comply with having all applicable permits issued
October 16th.
by October the 16th. And table the case until our October 21st hearing.
I'll second, Michael second. All in favor?
Aye.
Aye, opposed? Motion passes 4-0.
And by issuing of permits, it means the permits are also paid for.
Right.
Well, they won't get issued if he's not paid for.
But I don't want him to think
Yeah.
that because he applied,
Yeah, that's,
he's met.
good point, yes.
Yeah.
Obtaining a permit involves actually paying for it, not just the application. Sometimes there's been confusion, not with you, but with
No, I
others.
understand. Thank you.
Okay,
Michael.
Michael. Okay, 6-6.
Next.
6-6, are you gonna, oh, she's gonna be there.
So 6.6, same address and same property owner, case number CEN -23-506. We're bringing this case for intent to lien, and the reason is this particular hearing was missed. And we wanted to give the owner the benefit of due process to have the intent to lien hearing. The amount that has accumulated will stay the same. However, we want to give them the opportunity of due process.
Sure.
So we are asking for an order of intent to lien. This was for violation section 1.9 for the swimming pool, which I believe has come into compliance. But we wish there are some fines that have accumulated, and we wish for them to have the opportunity to get this order.
How much are the fines?
Last time I looked, $99,500.
For the pool?
Yes,
Yeah.
from the
It-
time the order was done to compliance date.
The notice of violation was first given in December of 23. You came in front of this came in front of us in January of 24. You
Yeah.
complied 2 years later, almost in March of 25. So yeah, it did accumulate quite a bit.
I'm not sure, because I know the pool thing is that, I corrected at the same time the issue was put on my door. I'd like to see evidence. I'm not
Okay.
sure I went 2 years with a green pool.
Yeah, he did come into compliance, and I did verify with the code officer. I looked at the photographs.
Yeah.
He did come into compliance, but we just want to make sure we do the right way and give him this.
So if he's in compliance, he can apply for a fine
He can
reduction.
apply for the fine
Okay.
reduction for these two cases.
Okay, that would be 6.
So I was always under the impression the intent to lien was for the garage and the double fence, the fee for the fence. But the pool, I wasn't sure about.
No, those are totally different. Right now, as far as you being able to ask for a fine reduction, it's on the 2 pool cases.
Okay,
The ones that were done, we're done.
all right,
Yeah.
okay.
If he were to apply for a fine reduction by September 4th, would that be time to get on our agenda?
Hold on, like this is going in my head. So you saying I need to comply, right? With the pool?
You-
Okay,
apply for reduction on these two.
Oh, I have never applied for the reduction, you mean?
I'll- they come
Okay,
to-
now I understand. All right, so I was just saying that.
Say, you're in compliance.
Yes,
You have a large fine on both
right.
cases. Yeah, quite a bit of fine on both cases.
Okay,
And if you're in compliance, what a resident can do is ask the village.
For a
to bring
reduction.
it- You know, bring it back before us for a reduction. You're going, you know, to comply.
okay.
I'm asking for a reduction on,
Our goal as a board is to get things in compliance and make everything safe for the community.
Okay,
Okay, so if no more questions, I'll make a motion in cases one at a time. In case CEN 23 506, there was a violation, the property owner has come into compliance. Give the property owner until September 4th to go into Village Hall, fill out a fine reduction request. He'll
Yes.
come back in front of us in September and we'll see where it goes from there. Should he not apply for the fine reduction in time, then set the intent to lien.
okay.
A second.
All in favor?
Aye.
Any opposed? Motion passes 5-0. Okay.
So we have a date on September 4th.
Yes.
what he does, and then we'll be at our hearing.
Mhm.
I would recommend you deal with it before September 4th.
I'll see her tomorrow.
Thanks. Okay,
Next,
Uh,
6.7,
same thing in 6.7?
I'll read out the case number.
Yep.
For the record, CEN 23 507, same property owner and same address.
So this is the other pool case that you are in compliance,
Yes.
but again, it has $101,250 in accrued fines. So I would make the same motion
Okay.
that by September 4th, preferably before that, go into Village Hall, fill out the fine reduction request, come back in front of us in September for the discussion. If we don't do that by September 4th, they will file the intent to lien.
Sure.
I'll send.
All in favor? Aye. Any opposed? Motion passes 5-0. Thank you. We will see you in September.
Thank you guys for your time. Thank you for your patience and energy.
All right, sir. Night.
So who seconded that one?
I did.
You did. Okay.
Next, case is, under section 6, old business, and it's 6.3. It's for the address 915 Northeast 118th Street. It's case number CEN 24 697, Yan Zhang Gregory Campbell White. Did I read that right? Authorization to foreclose.
6-3.
6.3.
I'm working.
The violation
It's hard to work with one hand.
was issued under section 16.14 double fee permits, a construction fence to the rear of the property that was installed without a permit. The fine has run up to $120,500.
It's homesteaded property.
Is it? 915, I would confirm. 915 Northeast 118. So they had applied for a permit at one time, but this permit was abandoned. It is a homestead.
And this was adjudicated at one time?
Located on first on,
Mm,
December 18th, 2024, when our fine gets paid. It was ended, order enforcement on March 12th, 2025. And, there was the full compliance, by
April the 23rd.
And we actually, there was, order to, move the lien.
In May.
in
Yeah.
May By 5,000, and it's since included $250 per day. Or, 1,500.
And during what communication have you had with the homeowner in that time?
I've been in the village for a few times, but hasn't been communication through her. I don't remember any communication. with
I
her.
uploaded everything to the website everything.
Website?
Yeah, I've uploaded all the measurements, all the photos. I've uploaded everything to the web-based thing
You applied for the permit?
a long time ago. Yeah, I mean, like,
Time ago.
I think in October or November of last year.
I have two
But that-
applications here for the one that you did in 2024. This is the copy, and then there's another one that was done in 2025, also for the fence, but both of them were abandoned. In fact, this one has an outstanding fee of $268. It went to P and Z, approved at P and Z, but it never went through for the rest of the building review.
I don't know what you're saying. I've uploaded everything I've been asked to upload, and this is just kind of falling through the
You're
cracks.
saying that you did that,
It was.
but you didn't pay the money.
Yeah.
It was approved, but then you didn't do anything about it.
I didn't, nobody asked me to pay any money. I didn't know it, I didn't know it was ever approved. I never received an email saying it was.
So you've
approved.
got to follow through to reach out. You don't just apply and then wait for something to happen.
Well, they were asking questions for more information, and I gave them the more information, and then
Once you
I never.
upload the paperwork and your permit starts going through review, it goes to the first inspector for review. That inspector will either approve or deny. It was denied. So they give you notes, they write notes in there that you are supposed to either provide this document or this is missing. And that's how you go from there. Like 2 years later, June 10, 2025. The review was done on June 17 and disapproved. So that was up to you now to connect with the reviewer and say, what do I need to do here? There's a disapproval, you receive a message once they disapprove.
Yeah, I haven't received an approval.
So what was approved? He already did it and it was,
It's been approved.
oh, it wasn't approved.
Then it's considered abandoned for 2 years.
So on June 17th or whatever you said, it was disapproved? Oh, disapproved. Okay. And because why?
In his photo, yeah, you can read the comments.
But it was an after the fact permit, correct?
After the fact permit, but it's still treated like a regular permit.
Right. So he's right. But what was wrong with it that it was disapproved?
Have access to the- Thank you for comment. Okay, go ahead, Raphael, if you see something.
I don't,
I don't have access.
unless I'm missing it, I don't see the disapproval.
I don't see it either.
June 12th, 2025, 9:01 a.m.
Is your speaker working? Your mic,
Hello.
that's working better. You gotta just get closer.
It says, please highlight the location of the replaced fence over the provided survey. The application reads, it is near the rear property line, but the survey of existing conditions shows a CMU low wall all along. Please be aware that the finished side of the fence must face the neighbors. Per the provided picture of the new fence, that seems not to be the case. Please clarify.
So the ugly side is on the outside.
Yes,
Yeah. So that's what they're saying, that you put the ugly side on the outside. It's not supposed to be.
I didn't put up a new fence. I replaced an old one when I bought the property. So what do you want? Like, just tell me what you want me to do to fix this. Like in English, like just dumb it down.
One thing I can share with you, having very, very recently gone through a pretty intensive permitting process in my own home. I'm going to strongly urge you, just don't go onto the system, plug in your information and not keep on top of it over and over again. Things will pop up, things that the faster you fix them, the faster this gets cleared. So there is a responsibility on the homeowner for consistent follow through. Don't just totally depend on what you put in the system. that's critical to making it move faster, we might not still be here. Now, Doreen, does he need to start all over?
Absolutely.
Okay,
That's fine.
they're old. The applications are what, a year, 2 years old?
So in English, it sounds like you have to apply for another permit. It sounds like they will approve it if you put the good side on the outside.
Well, apparently there's more to it than that. It looked like from what I was reading, positioning, setback, et cetera, there may be more to it than that, so we probably don't want to get into that in specifics, just in case. Because we're not out there.
You can find out when the building official will be, once you get your permit, find out when the building official will be at City Hall and meet with them.
Yeah, make the thing. We can arrange for a meeting, you in the building.
Actually, that might, if it's not imposing, since there seems to be question as to positioning, would that be something perhaps they could come out before he applies? Because once the gentleman applies and he gets rejected,
And they can explain to him what he needs to do.
okay, cool. So it's kind of like get this moving now for him.
I know the building official only comes in certain days.
Yes.
Mhm.
Yeah, we're fortunate that the assistant comes in basically every day. So if he can come in tomorrow, Thursday, for sure, they'll be there tomorrow, both of them.
What time?
They come in at 2:00.
All right, I'll be there tomorrow at 2 o'clock.
And this would be almost another incident similar to what we had before, until around October the 16th. That would give
Yeah.
ample time to resolve any
Okay.
issues and have it submitted to go before the planning and design.
Right.
And, okay. If there's no questions, I'd like to.
Please.
Make a motion on case number CEN-24-097, to give the property owner until October the 16th to have a fully issued, permit. If not, yeah, if not,
The-
the village, huh?
Authorization to foreclose?
Pardon?
What they're asking for is the authorization to
If
foreclose.
not, the village is, to move forward with the authorization to foreclose.
I'll second. All in favor?
Aye.
Aye. Any opposed? Motion passes 5-0.
If you run into any problems and need some extra time, then you need to talk to the village.
Thanks.
All right.
Good luck.
Next thing is, under new business, under 7.1. 1016 Northeast 114th Street, case CE -26-0229. Property owner is 1016 Northeast 114th Street LLC, in care of the registered agent Northwest Registered Agent LLC. We're asking for an order of enforcement. They're non-compliant, found to be in violation of section 8.4 to 7.b. Lot maintenance and cleanup. They have a rodent infestation, and this is an Airbnb, it's a something.
This was in front of us a little while ago, wasn't it?
Yes.
Okay.
And we had this sort of last month, but it hadn't been agendized properly, so we tabled it. 171.
Hi, sorry, I don't.
Hang on.
Okay.
Questions from the board? So if you would identify yourself and your relationship to the property.
Okay. My name is Johansson Roman. I work for the owner for the property management. So, we have a problem with mice. Sorry, I don't speak English very well, but I'll do my best.
Okay, better than my Spanish, go for it.
So we have, I hope was isolated incident because we have two inspections. The lady who did the claim to the city, he called the Department of Hotels and Restaurants. We had an inspection. So they told us and they give to us like a report where side that the house was clean. They didn't find evidence of mice. So maybe it was a mistake. Someone left an open door and a mice getting by mistake or something like that. Because that's where for us.
Well, in reading the inspection reports, it doesn't say that there never was an infestation. It just says what's being done to control it.
It is a different report from the city. I sent an email to Vanessa, I think. It's a different report. Was two reports.
This is what we got.
No, other one from the Department of Hotel
Oh,
Hotels.
I see what you're
Restaurants.
saying. I understand, sir. But the point,
Same address.
That's from the private company that we have for monthly pest control,
private company versus from the state inspector.
but we have a second report from the city.
The thing we have to be concerned with, it's one thing in your own private home when these little critters get in and do whatever they do at South Florida, but you're running what is essentially a public facility. The standards have to be met at a high level to assure public safety, hence why your owner received this citation.
I understand.
Questions, comments?
No, I mean, at the time of the pictures and the
Mhm.
report from the resident at the time, there were
Yes.
droppings in several places, not just one.
No, correct.
When I inspected the Airbnb myself, I found mouse traps.
Yes, because we call the pest control people for do that just in case. I mean,
So those mouse traps were there when the lady was renting the place. And when I came
Yes.
there was another person renting the place and they
it's,
were,
it's part of the pest control monthly we have.
and then there were droppings by the pool.
You know, maybe the house is surrounding of vegetation everywhere. I mean,
I don't believe a guest that's coming from another city is leaving the door open.
I know this was a very.
Okay.
In fact, we give them a full refund. I mean, we have the same surprise first.
Okay, if there are any, no other questions? Would somebody like to make a motion?
CE -26-0299, that a violation had occurred, as now, well, seems to be mitigated now, and assess a fine of $250 and administrative costs of $250.
I'll second. All in favor? Aye. Any opposed? Motion passes 5-0. Thank you, sir.
Thank you to you. Have a good night.
You too, sir.
The next four cases are in new business. And they're under 7.2, 7.3, 7.4, and 7.5. The address is
Hello, everyone.
807 Northeast 11th Place. Our first case number CE -26-0355. Property owner Brief Corporation in care of their registered agent Alejandra Rosenthal. Now,
but-
for all four cases, we are asking for orders of enforcement for several maintenance issues. So will I read them one at a time?
And I need to leave.
Oh,
In this particular case, I'll be straight up again in the interest of transparency. Although the email I sent staff regarding this case did not precipitate the citation, they were in the process of it. The mere fact that I sent an email means I will be recusing myself. Damn.
I'll put it on the record that the chairperson of the board has recused herself from from these cases. So I'll go ahead and read the first case. We're asking for an order of enforcement found to be in violation of section 8.4.3.1, exterior surface. The next case is case number CE 26-0356. Next case is CE 26-0357, and the next case is CE 26-0358. 364. And to save the board time, I would like to mention that this property is under negotiation for a new purchaser. And they have already applied for a demo permit. So we are asking the board to give them time, the new owner to go ahead and get this permit to demolish the property.
So is this the new owner or
This is the new owner.
okay, this is the new owner. As of when?
How are
It's
you?
still
I'm the contractor for the bill, for the new bill.
So if you could just identify your name and
Yeah, my name is Carlos Bordagna. And I'm representing the property 1180607 Northeast 11th Place.
And when did you guys get possession of the property?
We are in between contracts right now, waiting for the attorney. But we already submitted demo permit and fence for construction, for the new construction. So it should be happening in the next few weeks.
So you own the property already,
No, not officially, but
contract.
but the property is not. Oh, you represent the owner?
I
of the
represent the owner. Yeah,
property- Of the current property owner?
the current owner. Yeah, yeah.
Okay.
We're gonna build for him.
And when did that change hands?
Well, that, I learned about it recently, last week was when I learned about it, but I don't know when the contract was.
Yeah, it's gonna be a joint and where we're gonna build for him. This property's been sitting for like 3 years already,
Or-
or more. And then that's where I jump in and I'm able to build it.
So on the first one, it's with the exterior walls, and that was issued under the prior, now that this is being demolished.
Correct, and all of the violations were property maintenance violations. That's why I didn't bother to read them, because if the property is going to be demolished, all of those violations become null and void.
They can still mow the yard.
Absolutely, that.
100%.
And once I learned that this gentleman will be working with the current owners to fix the property, I intend to have a sit down with him and let him know about the rest of the maintenance.
But I saw an email on August 7th from a Briff Corp. Is that you? Is that your email?
That's the actual owner.
Okay, that said that he was gonna get it taken care of like in a day or two.
We
That's
did.
the lawn.
They did a lot of work.
Yeah, we
with
did.
it.
They gave us 5 days for those violations, which is the fascia of the house. They gave us 5 days and we took care of them the first 2 days. That was us.
And they've been in communication like every other day. He sends me the messages too early. I don't like that, but but I appreciate that they've been in communication.
Okay, that's important.
Yeah,
If I may, the village is looking, to.
So just give them the time to go through the, correct.
To have the, demolition permit pulled and the construction fence, and about how long do you think that would take?
We were going to ask for 60, but maybe you could give them 90 days to be realistic.
And.
60 is fine.
Is good,
Yes, we're gonna move fast.
Fast, that's-
but sometimes the blockage in the city, so.
So it's not when you submit, it's to
Sure.
get it approved?
Yeah.
Okay,
Yeah.
all right.
90 days is more realistic.
I'm also, I should be about 2 months from submitting plans for the new construction. If not less, but yes, we're moving fast.
But for the purpose of this meeting, I believe 90 days.
90 days, so it'll be safe to say
It's safe.
for our here, well. Yeah. Well, we don't need to hear it again. My motion.
Are you guys building another soulless square?
No,
Box?
no, we're not doing those anymore.
Get
Good.
permits and,
Good.
Did you see the one on 121st
Right, just.
with the arches? Where
Oh,
the
that's you?
cabin was?
Just a
minute.
That's awesome. That's gonna be,
So for our purposes before motion, 90 days, and then, if not, we can enter, we can assess fines.
Correct.
Okay,
If not, I would bring them back now for him.
right, but it'd be their responsibility. Right, I don't want to have to hear it if we don't have to hear it.
No, I'll chase them.
and if yes, fines are removed?
They haven't assessed any fines.
Okay. Oh, okay.
If you don't go through with what you just said,
We will.
then they would assess fine. I'll bring all cases back for fine assessment.
I just have one other question, because I'd like to keep them all together somehow.
Yeah,
Well,
okay.
and except for with the overgrown grass, you said been in communication, is it still overgrown?
No, they did cut it.
It is cut.
Yes,
Okay, so that can be dismissed.
yes.
All right,
Yes, we set up a landscaper for every 2 weeks.
Please.
Yeah.
all right.
Yes.
If there's no other questions, sir, I'd like to make a motion on case number CE -26 -0355 and 26 -0357. Give the property owner until November the 16th to have fully issued permits for demolition permits. If not, a $250 fine on each case, $250 administrative fee for each case, and $250 per day fine until the permit is obtained on each case.
I'll second.
That includes 7.5. You only called 7.2 and 7.
Are you gonna dismiss the other one?
7, we have, and 7.5, but that number, 7 on.
So the 7.5 is the wood face.
That's the last one.
The roof signs of this color, it's the same, similar.
CE 26.
The overgrown grass is 7.3.
And then, the C one,
So then-
26, that's 3035.
7.5 is 036.
So that one will be November 16 as well.
I just don't have that. Oh, here it is. So sorry, guys. On the second case, I'm gonna take 7.3 and then I'll go to 7.
Okay.
Case number 7.3, case number CE -26 -0356. That the property is in compliance and move to dismiss.
A second.
All in favor?
Favor? And on case number CE -26 -0364, give the property owner until November the 16th to have all applicable permits in place. Fully in place. If not, assessing fine of $250, administrative cost of $250, and a daily fine of $250.
I'll second.
All in favor?
Aye.
Thank you very much. Good night.
So the one with the arches, the 3 arches, like on that thing?
Yeah.
that whole square, what is that gonna be? Is that gonna be like a door or
That's an entrance. That's like a out exterior porch. Yeah,
it's gonna be like on the door is gonna be the one facing the road?
the
the
door,
sides?
it's back in.
The one that's back in?
Yeah.
What are those 3 arches? Windows?
Yeah, it's just an opening. Yeah, it's just a porch.
Very, very interesting.
Yeah,
I like that.
you can swim by and look at it whenever you want.
Oh, great.
Yeah. All
Appreciate it.
right, good night.
Night.
Thank you.
This is. Yes, you're gonna wait for her.
You know why you give it to me?
No more practice. Judy, yeah.
So that was 2, 3, 4, and 5? Okay.
In short, it was,
I gotta make my notes here,
Yeah,
here for the orders.
okay.
So
So the order
two.
for 7-2,
Mhm.
7-3, and 7-5 was, give the property owner until November the 16th. Have a fully issued permit for the demolition. If not, a $250 fine plus $250 admin costs on each case. Plus, daily fine of $250.
So that's on
That was-
2,
That was
4,
4,
5.
and 5.
fine. And that was Dale and, Judy. Right, Judy?
Yep.
Then on 7-3.
Bear with me, I don't take shorthand.
Like anybody drink over here, get water?
No, thanks. I've got one right here.
Then,
Okay.
in Smith's, like, Dale.
So just let me repeat it back just to be sure, because I have to get the orders correct. So on 2, 4, and 5, give the property owner until November 16th to pull it, to have a fully issued demo permit, or else $250 citation, $250 admin, $250 daily. On 3, dismissed. Now, my only question, and this is irrelevant at this moment, but I'm going to ask it anyway. We have a situation, ironically, on a property just north of this property where we've been hearing about demo for a long time, and it's still sitting there. You know which one I mean?
Yes.
So we kind of and we made them clean up, since the potential was that it was still going to sit there. Up north with me, not this one.
This one already, has a contractor who, that was the
That
contractor.
was the
He
contractor.
Here. That was the
Okay.
contract. They've already initiated,
Okay, because my only reason for bringing that up, I'm a bit nudgy about being able to justify everything we do. And if we've done one thing for one property that is pretty much the identical situation,
The chairperson is right, and I have personally started following up on these cases and just
'Cause
literally chase them.
they
because
actually cleaned up pretty well on that other one.
I wasn't happy with that cleanup.
Oh, okay, never mind. Guess they didn't. No, that's a different one. That's down the street. You can't keep track, Michael. Believe me.
With the tank that has to go to North Miami, the one on the other side.
Yeah, yeah.
But this one and there's a couple more, I literally have to get in there and push them. Because some of it is not their fault, because dirt takes a long time and, but I keep an eye just to make sure they're doing what they're supposed to do. Because I don't want those properties in that way either, so I take it upon myself to chase them.
We appreciate it.
Believe me. Not easy writing and talking with only one hand.
So
Okay,
the next two cases, we have Miss Brownell on Zoom by telephone. It's in section 6, old business, and the 6.1 and 6.2. 860 Northeast 120th Street, for case number CEN-24701. And the other one is CEN-24702, Catherine Brownell, authorization to foreclose. This is a duplex that we violated for a non-compliant driveway. They have, however, complied. The driveway is installed. However, the fines are still outstanding. We have 43,750 for each side of the property.
I'll ask, is this a homesteaded property?
No, it's not. Oh, it has homestead. She doesn't live there though. It is homesteaded legally.
Well, And if the property owner's not residing there, that's
Yeah, it's been
available.
vacant for a long time.
Okay.
They just need to update the records. So Catherine, can you hear us?
Yes, I can. Good evening.
Good evening.
And I go down there. I go down only for a couple days, but I live up in Palm Beach County.
Ma'am, bear with me a moment.
But-
I need you to please identify yourself and your relationship to the property. This is just for the record.
Oh, yes, ma'am. My name is Catherine Brownell, and I'm the owner of the property.
I think I remember when this came up the first time and Miss Brownell was here, and I think that she said she was speaking to a realtor. I think his name was I forget his name, but she was gonna sell it and then nothing happened and then the driveway went in, right? Does that kind of follow the timeline?
Yeah, yes. Well, the realtor was supposed to be working on getting the driveway put in, and then he didn't follow through. And I called a couple other people to come by, and they weren't interested with it. And then I had a contractor from up here in Palm Beach County come down and try to take care of the situation, which was putting the driveway in and everything.
I'm looking here that the property owner apparently has paid both the administrative and the violation fine. Am I correct? And at this point, what I would like to do is simply give her a deadline to come back and apply for a fine reduction.
Mm-hmm.
I mean,
That's if she would like to.
That if she would like to apply, I mean,
probably would.
Yeah.
I
Might be done on the others.
think it's pretty safe that,
we suggested, we do inform the residents what the
Right.
process is, and it's up to them, yeah.
And I believe we had given the time frame of September the 4th.
fourth, correct.
The other two.
I'm looking for the total here.
The total, yes.
I'm sorry, 42,750, 43,750. Per case.
Yes.
And you've been in communication with the owner, correct?
Well, one thing I would like to get on record was that I understand most communications were being sent to the residents down there, but I had informed last year that, anything that needed to be sent, to send it to this address up here. Because back, I don't remember exactly the date, but I believe it was in May that I had to fill out a form for a one-time payment of $1,000, and that had all of my information on it, my new address, email, everything.
That was the 250 on each case. However, there was still fines running before the driveway was installed. Catherine, we do make it a point to email you every notice that goes out of the city to make sure you get it.
And I can say that I may have missed them. I cannot say that I didn't, okay? There's a possibility. I've had a lot of medical conditions and I'm
Yes.
not really on top of all this stuff, I'm sorry to say.
But as far as the address, she says she wants things mailed to, do you have that address?
Yes, we do.
Okay.
Dr. Hatchie, right?
Yes.
Yes, we do have that address. The police gave me the
But
address.
I-
The reason we don't really use that address, Catherine, is legally, we are supposed to use the address that's in the property appraiser. So if you can change your address in the property appraiser, your mailing address, just the mailing part, we'll be able to use that address legally. So the reason we email
Oh.
is, that extra thing to do to make sure she gets it.
And if it's
Oh,
reflecting
oh,
the
okay.
homestead
All right,
property,
I'm sorry, I
Exactly.
wasn't
take care
aware of that. Okay.
If she chooses to apply for a fine reduction, can she do so via
Absolutely.
email or?
Yes, we can send her the information and the credit card authorization, and she can apply for fine reduction and can appear on Zoom for the meeting.
Okay. Ma'am,
Oh,
I
I
don't know if you're
appreciate that.
hearing our conversation, okay?
Mm.
If you so choose, at this point, you can apply for a fine reduction. You have daily fines that have accrued for both violations due to the time it took to come into compliance, but you are certainly entitled, now that it's complied, to come back and apply for a fine reduction. If that's okay with you, we will set a deadline for you and staff will send you the necessary information.
Oh, okay, all right. I'm not sure how that works, you know,
We'll
far as-
explain. We'll reach out.
okay. All right, if that can be done, I would appreciate that.
Look out for the information in your email, okay?
Okay, I will.
Okay, yeah, I'd like to make a motion. In CEN 24-701 and 702, the property owner has now come into compliance. Give the property owner until September 4th to apply for a fine reduction. If not, institute the foreclosure.
I'll second.
All in favor?
Aye.
Opposed? Motion passes 5-0. Ma'am, staff will be, is she still on?
Yes.
Okay.
Yes,
Ma'am,
ma'am. Yes,
staff
ma'am.
will be sending you the information you need. They will be glad to explain all the steps. You'll fill out the form before it's September 4th. And if you want to, you'll zoom in. Well, we would like you, of course, to zoom in again for our September meeting so you can negotiate a fine reduction.
Okay, and when is the next September meeting?
Bear with me. I will tell you that in a
The
moment.
19th,
The 19th,
September 19th.
September 19th, ma'am.
The 19th, okay. All right, I have to submit before the 4th of September, and then I'll be hearing something on the 19th of September.
No, September 19th.
At that meeting.
It's a meeting.
Saturday.
Oh,
Yeah, at the,
can't be the
yeah.
19th. Sorry, 16th? 16th?
16th.
September 16th, ma'am. We're sorry.
Okay, all right.
Annie, she had
I-
two cases.
I've read them both.
Oh, okay.
Yeah.
Yeah.
I read both numbers. Thank you.
So we'll see you soon and your driveway looks good.
Really does.
Thank you very, very much, and thank you for all your help tonight, people. I appreciate
You're
it.
quite welcome, ma'am. Thank you for zooming in.
Thank
Bye,
you.
Catherine.
Have a great, good night, everyone.
Good night.
You too.
And next one,
6.8.
yes. The next cases, I think 7, 8 of them. From
How do I do
6.8 to 6.14.
Hang on, I'm missing.
The address is 11401 Northeast 8th Court. First case numbers,
I am.
CEN -24-122. Property appraiser information protected under chapter 119 of the Florida statutes. Action order of authorization to foreclose was found to be in violation of section 8.4.5D. Storm shutters or protective window cover placements that have, they've been permanently closed, so there's no access through the windows. They're boarded up. No non-compliant, no communication from the owner.
Do we know if he's alive?
From the police, yes, they say he is alive, but not well.
And no family? Nobody's contacted you? Nobody?
PD did contact one of the family members.
Oh, I know this case. Yes,
I don't know if I should say it on the record.
yeah, on the record, it's hard to say.
And so there was no response to the.
We haven't,
Provided.
no,
Okay.
no,
And
no
all-
response whatsoever.
Well, if there's no questions, I'd like to make a motion
Absolutely.
on all of the following cases, CE N 24 122, CN 24 156, CN 24 708, CEN 24 709, CE 25 0015, CE 25 0360, and CE 25 0364. Direct the village to move and will close.
I'll second. All in favor?
Aye.
Okay, any opposed? Motion passes 5-0.
I would like to put it on the record as well that I am working with the building official to bring this case before the Unsafe Structure Board of Miami-Dade County to get an order for demolition of this property.
Are we clear with all the cases?
Cases we brought before tonight. And we open this to the board now to discuss 5.1, the addition, admissibility of police officer sworn incident reports.
This is absolutely exactly what I was hoping we would get. It just makes it so much clearer that it gives us a better definition so we can be more comfortable with what our rules are or aren't, and makes it a simple process. I mean, but now I do note one difference though. It can't be a straight police report like we were getting. It needs to be, please stop me if I'm wrong, an actual notarized statement. In other words,
That's correct.
not exactly, Michael.
When did we get this? Is this an add-on?
No, it was on our agenda.
It's in the package,
Yeah, it was,
What number is it?
it,
5.1.
5-1. It was in our agenda packet.
I don't see it in my.
It-
No,
It'll be on your agenda.
mine starts with 6.1.
It's, well, it's a, here, I'll show you. Here,
Minutes, memorandum.
So in the package,
Oh.
it was memorandum
yeah.
in the.
It-
Yeah.
No, I got this one. Okay. No, it just says memorandum. It doesn't say 5.1.
Sorry. But, because am I correct, police officers, minimum overtime is 4 hours?
That's correct. So
So,
even if they come for 5 minutes, they
right.
have to
So,
be paid
yeah,
for 4
when
hours.
You run into the situation, we could subpoena them to be here and find out that the property owner isn't even here. So this way, if there's a way to reach out, when we know we have a case that does involve police testimony, if there's way to confirm as to whether or not the property owner is going to be here, do they want to cross-examine? So before we subpoena, we now have a process to do it the right way, fair to everybody. And that's great. Please thank John for us.
I'm still reading this, so just give me a moment.
Okay, we'll start this in. Questions?
No, I didn't have any
Questions?
questions.
No, I'm good.
To me, if the police officer is provided a fully documented report,
And we know now it has to be notarized and sworn. Right.
sworn affidavit, then that should hopefully answer a number of questions in regards just to the facts.
But Michael, I appreciate you kind of nudging us forward, so at least we had the incentive here to get a procedure in place. And while I don't want to see police officers dragged in here on a day off and paying overtime that's unnecessary, we're going to do the right thing. And this, I think, helps us a lot more to have a procedure that we all now know what we need to do. Okay. While Michael's reading, Michael, if you don't mind, I'm going to go on to the minutes while you're
Yeah,
reading.
go ahead.
Is that okay? Everybody have time to read the minutes?
Yep.
Any changes, corrections?
Well, to be perfectly honest, I could not find, what happened last month. I read over them, it appeared to be good to me, but my recollection, but then I didn't have my minute, this last month, so.
Wasn't there.
I have two questions on 7/2 and 7/3. I have a date of July 31st. Oh, and you didn't have notes. Keep it here. I'm sorry?
It was July 17th.
It was 17th? Okay, thank you.
They paid it.
I-
Oh, they paid it already.
I believe her. So, bad news. See? Okay. I have, then I'm good.
Because I disclosed that from recollection, they appear all good to me, but I
Okay.
would not like to make a motion to, but rather.
Would you-
simply actually have them.
Would you rather table it? Do you have notes at home or you just don't have the
No,
notes?
if you've gone through it. to
Okay,
me, my
yeah.
recollection,
Okay.
I found. And have a decent memory, still, that it appeared
Well-
correct,
Okay, then I'll make a motion to approve July 15th code board minutes as written. All in favor? Aye. Any opposed? Motion passes 5-0.
I just didn't want to.
No, of course. Sorry about all the noise when this rolls. Do we have a stand for this by any chance? Because honestly, this works much better for me. It's up there. Oh, if we could find another one somewhere, this works so much better. But, try writing and doing and no, it's not working.
Let's see if you can bend it, it won't.
No.
Say if you could bend it
Okay,
into.
so,
No. Okay.
so I've had a chance to look at this and it says that fundamental due process shall be observed and shall govern the proceedings, okay? I'm looking at the memorandum, page 1, the highlighted section here. I just highlighted it. It says that also on fundamental due process, which is at the bottom of page 2, it says, although the rules of evidence are relaxed because it's quasi judicial, fundamental due process pursuant to Florida statute 162.071 requires that fundamental due process be observed. It is necessary to fill the procedural gaps by common sense application of the basic rules of due process. And that due process in a quasi judicial code enforcement proceeding requires at a minimum, number 1, adequate notice of the alleged violation in the hearing. We do that. And a meaningful opportunity to be heard, including the right to present evidence and to cross-examine the witnesses. And that they quote a 1982 case out of the Supreme Court of Florida. And then they say that the cross-examination component is a principal tension point. A respondent could argue that admitting a written report without the officer present denies the opportunity to cross-examine the accusing witness. However, several factors weigh against requiring in-person in every case.
Right.
So now it also says in the next page, second paragraph, the board has broad discretion to determine what evidence to admit and to weigh, to give weight to be given to such evidence. We may reasonably conclude that a notarized incident report is sufficient, but it's not necessary. And that the respondent or the defendant, however you want to call them, can request to cross-examine. Now, my problem is, and particularly with going, first of all, I believe that, and I'll say this on the record, that this is a thinly veiled attempt to not pay the officers and not to require due process, which is the fundamental principle of any proceeding, is the ability and the right to cross-examine. Now, I understand that there is that in a quasi-judicial process that it is relaxed somewhat. However, I believe that our village unfortunately has a bad history with our police officers, including officers right now that are sitting in federal prison, including a police chief, for making up incident reports to get a quote-unquote 100% conviction rate of young African-American males and set them up and got caught and is sitting in a federal prison because of that. Now, to say, well, we're just going to accept notarized affidavits of the police force is not something that I can get behind and accept at face value, particularly given the history, the unfortunate history of our Village of Biscayne Park Police Department.
Michael, you do realize a couple of things. The incidents you're referencing are at least 12 years old and have nothing whatsoever to do with current administration, current chief, or current staff. While I totally respect your concerns, I think that's kind of borderline out of line and a little on the unfair side when you're talking a 12-year-old situation to say that because of what happened in 2014, it could happen again today. Yes, it could happen again tomorrow. We have no reason to believe that. And I'm going to trust the village attorney to not have put this village in any precarious situation.
I look at it that this is really not a criminal, but more of a
Civil.
abiding
Civil.
to our- Yes.
Right.
so Not abiding to our codes, and if we have a resident calling on a case and police are responding, pretty much a report. To me, I could weigh that in, especially if it's been notarized, a sworn affidavit, as to, now we have a resident as well as,
The officer, right.
Well-
You have what is, the officer gains nothing by having a prosecutorial attitude towards somebody who's making noise, and you have a resident who has to have called it in. Very different from the situation you're talking about.
Well, I'm talking about a history of the police department, whether it's a current administration or not. It's something that we have to recognize, and you learn from the present and the future by what's happened in the past.
Of course.
And all I got to say is that every single case where there has been a police officer that's come in here and testify with regard to the complaints that were made, that were brought before the board, I believe that we voted unanimously in every single case once we heard the evidence. So if it's not about getting a police officer to come in here and to testify and to allow the resident to have the fundamental due process that they should be afforded as the village, why would we be taking a shortcut on that? What is the reason? If
Quite
not
honestly,
financial.
I honestly don't recall that every time the officers have been here, anybody has cross-examined them. So
I've cross-examined them.
But the people you purport to be concerned about, the resident, property owner hasn't, and that's the whole point of the due process, is for the property owner. They haven't done it.
Does the noise complaints that have been issued, does it say in there that you have the right to cross-examine the officers when these violations are made? Yeah. Okay, so when they get the notice as a layperson, there is no information that's provided to the resident that they have the opportunity to require the police officer to be there and to cross-examine them at the hearing?
It's what I read at the beginning of the meeting. If they want their case tabled to have the police officer here, we will do that. I
Okay,
read that at the beginning of the meeting.
all right, that's fine. If they come up here and they say that they want to cross-examine the police officer, then we table it.
Yeah.
Okay,
Yeah.
That's what it reads on the last page of this memorandum, that they have,
Exactly.
that's right.
they
Okay,
can appeal, they can request the presence of the officers, but timely before our meeting is.
well, that's the thing. They're not told before. They told at the hearing.
if
But we
you
all agree
listen-
right now that if they want to require it at the hearing, then we'll table it.
Well, John says it.
Timely.
John says it right in here.
That's right.
Table the meeting, I'm sorry, table the case if they ask to have the officer.
I'm okay with that. I'm okay with that.
So am I.
Because we could tell them they have the right to appeal in the notice of violation 10 days after they have the right to appeal. So we can add in there that, you know, if the case goes before the board and you need to call the witness from the state, but the witness from the city, you are allowed to do that.
And if they're here and they want, and they request it, then we'll table it. I'm okay with that.
I would like to see is in our notices.
Yes.
To let them, for them to be put on notice that if they want to have, the officer present, they need to notify us in advance. That
Oh,
way it's sort of-
John says it right at,
Notice to appear and they're seeing, if I want to have this officer, you need to let us know 10 days in advance.
John says 5 business days.
No, he said EG. They said, for example, you just suggested that they can do it when they're up here, and
Yeah,
I'm
but-
fine with that.
I would also like it to be in the notice because.
I'd like to be in the notice too.
Because John says 5 business days in advance to let us know.
He
So
didn't
why not
say-
put it
he
in
gave
there?
an example. E period, G period means for example.
Okay, I know what EG means. I get
Okay.
it.
So are we gonna, so is the village attorney going to review the language that's provided to the, to the violator? The alleged violator, who's presumed innocent? Okay, thank you.
What is that?
If we could put these as part of the notes, I'm sorry, the minutes for this month, so that they're really on the record. Okay, that was,
Entertain a motion to adjourn.
oh, absolutely.
Make-
Second,